Hi, everybody. Welcome back to another episode of Taxel Insiders. I'm Brian Seidensticker. I'm CEO of Taxel Resources. And with me today, I've got the guy, the man, the one and only Scott Walterbach. He's one of the few attorneys in Missouri that are well versed in the tax sale process in Missouri. Scott, welcome back.
Welcome. Well, thank you, and it's good to be with you today.
And I know everyone's sitting on the edge of their chair to hear all about what you wanted to talk about, and I don't want to get into too much detail on a lot of different topics, but we were just briefly talking before we hopped on here of some of the ideas. But I think one of the ones that definitely sticks out, and I think some new investors in the space fail to realize and maybe get burned by this if they don't pay attention to it. But it's the stuff that sticks with the property through the tax sale process. The interest that survive or may survive, right? Depending on the state statutes, maybe federal law and that sort of thing. So maybe, can you talk a little bit about what types of things survive, how they survive, and maybe if we have time, get into how those can be mitigated or if they can be mitigated?
Yes, absolutely. First of all, you got to remember that when on the properties on which you do end up getting a deed, the collector doesn't give you any warranties of title, right? And so they're not guaranteeing that any particular thing happened or didn't happen, or any particular interest is foreclosed and extinguished or not. And so you can only really get that from learning lessons the hard way from experience, or a knowledgeable attorney that can kind of walk you through that. Now, generally, in the statute under which most of the counties in Missouri operate is Chapter 140. And under that statute, there's essentially four interests that survive that you're never going to extinguish no matter what. And those are subsequently due taxes. I think we've talked about that before, how you never get out of paying taxes that come due after the tax sale, right? That seems obvious. The other one is valid recorded covenants running with the land. So if there are recorded covenants, and usually those are enforced by like an HOA or something like that, those are going to continue to run with the land. And there's some discussion about, well, what exactly is a covenant and what is not, and that's sort of beyond our scope here. But generally, those are things like you would typically think of, like your HOA type restrictions, like you can't paint your house certain colors, or you can't have solar panels on your roof. That's one of the rules in my neighborhood. If you bought a tax sale property in my neighborhood, you wouldn't be able to put solar panels on your roof, that kind of thing. And then the other two, so I mentioned four that are within Chapter 140 itself. The other two are easements of record and easements in use. So easements of record would be pretty easy to learn about. Those would be things like sidewalks, utilities, different rights of way and things that are going on with the property. If somebody has a driveway easement for ingress and egress to their property, those types of things. What's an easement in use? Well, it'd be something that you would be on constructive notice had you viewed the property. Usually that's like a walking path, a driveway, a fence, something like that you could see. If that has ripened into an easement, then that would survive the tax sale. Okay, but there's more. Recently, we had a case about whether or not a lien from the Department of Housing and Urban Development survived the tax sale. And the case was removed to federal court, and the federal court said, yeah, Missouri's foreclosure process is non-judicial, and therefore certain liens of the federal government survived that process because the United States did not get a notice in the form of a judicial notice. And so that's a fairly new development, and we're thinking through ways that we can mitigate that. But right now, if you bid on a property at a first or second offering, let's say in a county that uses Chapter 140, which is most of them, if you found out after the fact that that property had a HUD lien on it, that becomes a really difficult thing because there's no easy way to foreclose them out even if you get a deed later on. And that's sort of by operation of federal law, not by state law. Now, the um, the U.S. attorney here seems to think that applies to all federal liens. I'm not sure that's the case. I still think, due to certain IRS regulations, that IRS liens, if you do your notices properly, the IRS liens are still secondary to state taxes and sort of, for lack of a better term, subjugated and can be extinguished. But I don't know that there's a real clear answer to that under state law. My experience has been that we send notice compliant with IRS regulations that they typically disclaim. HUD, and I also had one, for example, where the former owner of the property committed some sort of crime. He was prosecuted federally, and they got a judgment against him for restitution. So there was a restitution judgment in which the Department of Justice was the lien holder. And so there's a possibility that that type of thing might survive also. So you got to watch out for federal liens, and if you have one, think through what you might need to do to send notice. Be a good thing to talk to your attorney about. I was talking to another attorney this week about Illinois sales, and he was talking about, well, that's just a sale in error in Illinois, and you have an easy way to go set that aside. And he's also a Missouri attorney, and so am I, obviously. And we talked about how there's no real mechanism for a sale in error, so to speak, in Missouri. You're just kind of, you take subject to that interest, and I'm not sure there's much you can do about it to get your money back or cancel the sale or otherwise. So there's the federal liens. We're still kind of sorting through that. The other things
Illinois
that
got that unique sale and error. I mean, the only other state I'm aware of that has a sale and error provision is Arizona, but it's not used as I'll say openly in every case where it's like, oh, the property wasn't there, sale and error, get my money back. Illinois.
Yeah, this attorney, and like I said, I'm not licensed in Illinois, but this attorney made it sound like it was just kind of like, for any reason you thought maybe you weren't getting what you thought you were getting and you didn't want to go forward, you could just go get your money back and everybody kind of goes home. Well, there's nothing like that in Missouri. So to the extent, especially if you're interested in just a few properties, it'd be best to go get educated about the owners and encumbrances on that property before you bid. If you're bidding on lots of properties or all properties in the sale, well, that's different. That becomes harder to do. The other two things I'll mention are sewer district liens. And then in concert with that, you have certain things that are different types of assessments. The ones that come to mind are community improvement district, transportation development districts, and neighborhood improvement districts. And so Missouri just had a court opinion that came out here recently that said, look, the legislature has the power to elevate other types of debt or liens to be on par with taxes. They don't have to do that, but they have the power to do it. And if they do it, they do it. Well, if you dig into what that means for the sewer district, and this was a sewer district case specifically that I'm referencing, for sewer districts, it does essentially say that sewer district debts, not even liens, they don't even file a lien, but sewer district debts on the property, because I think the theory is that it's so fundamental to the functioning of the property to provide water to the property and sewer away from the property, really a property is uninhabitable without it. And so I think the theory there is that it's so fundamental that everybody's on constructive notice that that might be a thing. And if somebody hasn't paid their sewer bills, which especially on the eastern side of the state, there's plenty of sewer districts that have, unpaid and neglected sewer bills. So that's something that you want to be aware of. We're still working with some of the bigger sewer districts to figure out how we can come to know that prior to the sale. And I'm told there's some sort of a portal, I don't know much about it yet, where you can go see what's due. So the other things like CIDs, TDDs, and NIDs, you really have to go back into and dig into the statutes to see what they say about the priority of those assessments. Now, CIDs, for example, there's language in the statute that talks about not only the assessments being collected in the same manner as ad valorem taxes, but it also talks about the liens having the same priority, and they use that word priority in the statute. Transportation Development District liens, by contrast, they talk about TDD liens being, or TDD debts or assessments being collected in the same manner as taxes, but they don't talk about how it might have the same priority as taxes. So a lot of that's uncharted territory, but certainly that's something I'd want to be aware of. So if I were a bidder coming into Missouri, I'd say, okay, I know I'm not going to get out of subsequently due taxes, valid recorded covenants running with the land, easements of record and easements in use. No way I'm going to wipe out those. Now, if I have things like federal liens, sewer district liens, or assessments from CIDs, TDDs, or NIDs, then I want to look at that more carefully and make sure that I want to go forward. And if I choose to go forward with buying the property, that I do my notices right in order to mitigate their ability to come back later and say that it was not foreclosed for some reason.
Interesting. And actually, it runs very in parallel to some other states I'm familiar with. I mean, Florida's somewhat infamous in the lien world now for their CDDs, which community development districts, which sounds very similar to like a CID. And at least in Florida, it's they have enough case law now that it's been established that it is a priority and survives. But I had not heard of that being a thing in any other state. But it sounds like it may, depending on what the case.
It seems for whatever reason, it's sort of bubbling to the surface here lately, like within the last few years. And I don't know if that's driven by economics or what, but those issues are starting to come out. And there was just a case in the Southern District of Missouri. If it wasn't this year, it was last year, maybe in the fall, something like that. But very recent as far as legal things go. That's very, very recent. And it talks about when those types of things survive and when they don't. Unfortunately, the tax sale purchaser lost that case, but it gave us some real helpful language on how the courts are going to look at these things going forward. And maybe if the facts are a little bit different, we sort of have a window into how the courts would look at it. So I think I could advise my clients a little bit better on whether I think they survive or not. Of course, I wouldn't write any guarantees on it because some of that is, like I said, uncharted territory.
Does I have some scenario questions for you, but maybe before we get to that, of I'll say ways to mitigate each of those items from the, okay, it has an easement. Is there no way of mitigating it? Or it has an IRS lien on it, or it has a HUD lien. Are there ways of mitigating each of those, or is there any solution, or do you have to live with it in each of those scenarios?
I think the main answer I'm going to give is you have to live with it. Now, but if you know about it ahead of time, then you can adjust your bidding or your strategy accordingly, right? You can say, okay, well, I know there's this cell tower on the property, and I know all those things are on easements, so I know I'm buying this house next to us with a cell tower right on the property. There's nothing I'm gonna be able to do about that, so you just kind of take that into account. I would still certainly send those folks notices because I think they have an interest in the property and therefore may be entitled to notice. And so you don't want the whole sale to be defective. So first bit of mitigation would be to send them a notice, and maybe they redeem, maybe they don't. But if you come into ownership of the property, I'm not sure that there's a lot you can do about it. Certainly for the IRS, that's one that you can mitigate because I think even though it's a non-judicial foreclosure process and you may be able to get around it, you may not be able to get around it as far as HUD or DOJ or one of those other federal type lien holders. You may be able to get around it if it's the IRS. So you do that. So you do your noticing the way you always would. And we still notice, for example, we still notice the sewer districts, even though we may not wipe them out. Not the least of which reason is because then they're aware of the sale. And if there's a surplus, at least some of them have gotten diligent about going to claim the surplus and applying that to the debt. And hey, maybe you owe less, or the property owes less than you did before. So we still talk about notice and trying to do the notices correctly during the redemption period, but there's no magic bullet to clear those off. So, it's more of just a kind of a buyer beware thing. And to the extent you can be aware of it before you bid and adjust your strategy accordingly, that's the best case scenario.
Does it, I'll use like a HUD lien on it. Is there any ability to go through a quiet title and notice that, whoever the authority is on the HUD lien, and give them the chance to come forward? And if they don't, obviously they've relinquished their right on that? Is that even an option for
Yes.
things like that?
So, and I think that happens with some regularity to with other lien holders in the sense that they may have some kind of a lien or interest that may survive by some argument. Let's say, for example, one of the ways that something can survive that doesn't by law survive is that you didn't send them a proper notice and the court finds the constitutional due process failure on your part. Okay, well, you still bring them into the quiet title action, and if they don't dispute it, then the court would just award judgment in favor of the tax sale purchaser. That is not the case with the United States government. My experience is that when I have served them, not only have they entered the case and defended it, they don't even leave them in state court anymore. They're removing it to state to federal court, and they want to be in front of federal judges in the federal court system. It's a little more structured, and the judges, I think, while they may not understand state law as well as state judges do, they're perfectly capable of applying it, and the government gets the benefit of that more regimented federal court structure. Not to mention the attorneys for the United States are, a lot of them are experts in the federal rules of civil procedure. And so I think that's possible, but unlikely. I have a case right now where we don't think that HUD has an interest anymore, but they're still showing up in title due to a defect in a previous legal description in the chain of title. And because the timeline to remove is so short, it's been removed. My suspicion is that because the timeline to remove is so short, they've removed it while they're investigating whether or not they have an interest, and if they do, what it is. Because I hear that from lien holders from time to time. That's not unique to the United States government. Sometimes a bank or something like that, they just need more time to figure out why they're in the chain of title and where sometimes they're a successor in interest to a bank that was merged into theirs. And so sometimes it just takes some time for them to figure out what their interest in the property actually is, or why they're appearing in the title chain.
Got it. Interesting. What I want to throw a couple other scenarios that I've heard in other states. I don't know if this will directly apply to Missouri, but and then we'll maybe save these other topics for next time, Scott. But one of the scenarios that was brought up to me, this is actually Colorado, so I don't know if this will exactly apply in Missouri, but it was an investor that came to me, and I didn't have the answer for him. I said he needed to contact an attorney in Colorado. But basically, they found in the tax sale a bunch of parcels that were essentially the road to a development. And it wasn't like a portion of a house that extended into the road. Like the parcel was the road itself and the cul-de-sac and all that great stuff. And basically, what they wanted to do was buy them and then, I'll say, hold hostage, the owners and say, hey, I own your driveway, pay me X dollars and then I'll let you have your land back. Well, I mean, I think that's exactly a ease of use circumstance like you just mentioned. So let's say that did happen in Missouri where, someone bought all of these parcels that happened to be the road going into a development. It sounds like they really would have no leg to stand on because that ease of use overrides the fact that you own that property. I still need to have the ability to get to my property. Do I understand that correctly?
Yeah, I'd be reaching out to the assessor to figure out if that was assessed correctly and they intended to do that. Is there some reason they believe the road owes taxes? Because it's my impression that when those things are platted, you would assume that's not a separate tract, that's if it's not an easement of public records, certainly it's got to be an easement in use. You're on constructive notice that's the way that people access their property. And in Missouri, I haven't done a lot of research on this, but generally speaking, I think there's a common law right to ingress and egress to your property out to a road. So if it is a private road, I think you can still, even if somebody owes it on taxes, there's a use on which you would be on constructive notice for. So I don't think, even if you could own the property, I don't think you could hold anybody hostage, like put concrete blocks up and block use to it. I think you would take subject to that use for ingress and egress. So you'd have a road in theory that you own, but you wouldn't be able to block access to it. I don't know the answers to that question. It's an interesting hypothetical, but I have seen other situations where the legal description is such that, or the assessed parcel ID is such that it. I've seen one where the line runs right through the house, and
Right.
so we bought like half a house. And so we try to figure out those things. But yeah, driveways, those, but I haven't seen one that has to do with a road where where the road has been the actual assessed parcel in Missouri. But I did have one where we bought, it was essentially the house, and the neighbor's driveway kind of came into that property and went out to the road. And it's like, well, you're probably not going to be able to get rid of the neighbor's driveway. That's how they access their house. And so if it's not an easement of record where it's like, recited in a deed, certainly it's an easement in use of which you would be on constructive notice by viewing the property.
Right. Interesting. I do find it curious how in some states the whoever draws the lines or makes those decisions, I don't know if it's always the assessor, how they're a little more, I don't know, less attention to detail in some states or counties versus others, because
Certainly seems that way. I had that just reminded me of a case where the back half of like the house and the back half of the property was within the county, and then like the driveway and everything was in the neighboring county. So while the property that I was working on, we filed suit in X county where the house was and the backyard was. Turns out they have trash service because they put their trash out at the end of the driveway. They had trash service through the other county, and the other county put a lien on them for non-payment. So we filed our quiet title, and then the other county was arguing, well, you've sued us in the wrong county. We're entitled to be sued in our own county. I'm like, but this is a quiet title about this property in this county. We ended up getting it settled, but uh,
that's a
it's
unique
a really weird deal when those
situation.
lines are they go right through a driveway or right through a house or something. It's bizarre how that happens because when you have normal like platted subdivisions like within the last 30 years or 40 years, then it's not a problem. But sometimes you have these old weird areas of
Yeah.
unincorporated county that these issues come up, and you go pull it up on the county's geographic information system. You think, I'll be darned, the line goes right through the house or right
Yeah.
through the driveway.
Yep. What's the other one I've seen in Florida, where somehow they got the mailbox partitioned out as its own separate parcel, and people have bought it, right? Because it's got an address on it, bought it
Sure.
thinking it's a property, and then they find out they bought a 3 by 3 foot piece of property and not a whole lot of value to it. But
Right.
yeah, so okay, so the other scenario which you mentioned, the whole trash and some the other scenario that I've seen in other states, and I'm not sure if it falls in there that sticks with the property in Missouri or not, but maybe you can help me. Is I call them municipal fines. Trash, sewer, I think fall in that category. But the one that I've seen a lot in other states is non-mowing scenarios where, hey, you haven't mowed your lawn. If you don't mow it, the city's going to hire somebody to go mow it, and then they slap a lien on the property. And in states like Florida, they can get a little crazy with what those fines are. $500 a day, and multiply that over multiple years, ends up being a really hefty fine, and not necessarily a lien,
Right.
but a fine on that property. So, is that something that happens in Missouri as well? And do those stick, or is that considered?
Yeah, and I should qualify everything I say here. We're just kind of talking shop. This isn't legal advice. You shouldn't rely on it and all that good stuff. Get in touch with me if we have a specific factual scenario. You need some real legal advice on. Uh, but yes, we usually call them weeds, weed abatement, or like noxious weeds, or some different municipalities call them different things. Uh, but abatement essentially, and my argument has always been, and I think I've gotten most counties and cities to agree with me on this, that taxes survive, but there's no provision in Missouri law that I know of that would have those type of abatement services survive a tax sale. And I've even had some cities say, well, we agree that anything that was done prior to the tax sale would not be compensable by the tax sale purchaser. But once they bid at the tax sale and there's this whole year that goes by and we've mowed it 10 times, and what a private company would charge you, $50 for, they charge you 350, right? They say, well, during the redemption period, we think you owe that because, you have the tax sale certificate on the property. Well, I mean, give me a break. We have no right to possess the property. We could be trespassing if we go and mow it. Missouri law is pretty clear. We have an inchoate interest in the property during the redemption period, and that the owner still has um, a right to possess the property, especially if it's homestead property. So I believe that all of those would be extinguished. That doesn't mean we don't get pushback, and that doesn't mean at times, because of the de minimis nature of those, sometimes, if it's $100 or whatever, we're probably not going to fight them in court, probably just going to pay it and move on, that kind of thing. So that does happen sometimes. So I can't say they're foolish for trying to pursue that, even though they may not have a real legal basis. I don't know that there's a lot under Missouri law that you could point to as authority that would support you. But like I said, we look to how the law is structured. What does it specifically provide for that survives the tax sale? And then where else can we look to under either case law or other statutes that talk about something being on par with taxes, or having the same priority as taxes, being collected in the same manner as ad valorem taxes? What are all those things? And if it doesn't fit into any one of those categories, which I think the nuisance abatement type stuff does not fit into any of those categories, then I just tell them, look, you undertook that at your own risk. And that's not to say when we get our collector's deed that the former owner doesn't still owe that. It was their property at the time. You provided a service for them. They still owe it. It's just any lien that was attached to the property gets stripped off because we're foreclosing a superior interest.
Got it. Interesting. I find it curious how each state, treats things slightly different. So anyway, Scott, I think there's a couple more topics, but we'll save that for next time. I greatly appreciate helping educate me and us on what happens, and how, again, everybody that's listening, this is specific to Missouri. This isn't a nationwide scenario and what happens. But Scott, thank you again for your time, and I look forward to our next chat.
Yeah, thank you for having me. It's always a pleasure. I look forward to doing it again sometime.